statement is, according to the control room, he is not going to vote for evidence.
There you go.
Did he say specifically witnesses?
No need for more evidence.
No need for more evidence, according to Senator Sanders' statement. So, but that means that who the remaining, I mean, you never know, but the likely candidates, if there are going to be enough witnesses to make this an open question, are Senator Murkowski and Senator Romney. That would get you to 3. If there are additional senators who might be yeses, then it's a clear yes, and then we move on to that portion of the trial. If there are only 3, if it is Murkowski, Collins, and Romney, then the vote, if all Democrats stick together on this issue, would be 50-50. And then that would put us in the position that we were just discussing earlier, in which the Supreme Court's Chief Justice has to decide whether or not that 50-50 tie results in the measure failing, or whether he would like to be a tie-breaking vote so that it passes.
Right, and we had discussed this earlier during the show, between the show, yesterday, today, but why don't you start?
I've been thinking about it in my sleep.
But why don't you go first, Maya?
Well, the point I will make, and that I hope everyone carries with them whatever happens if we're in this situation, is that whatever happens, it's the responsibility of the outcome lay with the Senate. It lays with the Senate, because this is not a situation in which there should be any question about whether this Senate, in acquitting its oath and its constitutional obligation, should agree across the aisle to hear relevant witnesses. And I think that is the most important thing, not what the Chief Justice does. I understand why it feels important, because he has the ability to impact the outcome, but at the end of the day, the responsibility stays with the Senate.
And 2 points to add to that. Number one, a 50-50 tie is a defeat for a motion. So if it's 50-50 to call witnesses, no witnesses will be called. Number two, should we expect the Chief Justice to try and break the tie? And I think we've agreed that that's highly unlikely. He so prizes the independence of the federal judiciary and knows that a vote either way puts him on a team. And the last thing a federal judge...
it's a decision not to intervene or a decision to intervene. They're both active decisions.
And I could defend both decisions.
Sure.
I mean, just to be clear, if a different sitting Chief Justice made the decision to make a ruling on that vote, I think there is an argument that supports an intervention.
But he could also take the institutional notion, right, one step further. I am not a senator. I have never been a senator. I am not the vice president. I'm not the president of the Senate. I'm merely presiding over this trial. I have a limited role. And so I'm not going to vote. I agree.
That said, there is a precedent, right, in previous impeachment trials overseen by the Chief Justice. Right. In the Johnson impeachment trial, there was a tie in which the Chief Justice decided to weigh in. And
Salmon Chase was the Chief Justice. He also got overturned by the full Senate after doing it.
Exactly, which is possible for John Roberts in this situation.
Which is my point, that you can argue it either way. And that's why, if I don't think the founders ever expected, though, to be in a situation where you would have a fact witness with direct knowledge that would help the Senate make an informed decision, that they ever thought the Senate would say no.
Last night we had, guests and a noted Supreme Court journalist who covers the court for Slate. She, with all of her knowledge of Roberts, sitting in your seat last night, said, not this Chief Justice. Yeah. This is just, in her view, which is educated and informed, and I take her word that this is not going to happen from this Chief Justice.
Let me add this wrinkle to it. Mitch McConnell is feeling very big about what he's done to the federal judiciary. He feels very protective of the fact that he has loaded the judiciary with young conservative judges all over the country.
And that he held open hundreds of seats
and that he,
during the Obama years so that he could do it.
Exactly. And that he denied Merrick Garland even a hearing, blowing up the Constitution. So he doesn't want Roberts to be in this position. He does not want to put Roberts in the position where either the Republicans are going to see him as a traitor or the Democrats are going to see him as a traitor. So he will work extra hard overnight to get Lisa Murkowski to vote no.
So that Roberts won't
takes
have to
Roberts out of the hot seat and maintains Roberts' patina, which is maybe not a fair word, but patina of being completely, nobody's team, that he is completely a neutral arbiter. So I think McConnell will really turn on the afterburners now, trying to get it to be just 2 votes instead of 3.
Do you think that anybody else is in the mix besides Murkowski and Romney at this point?
I think that only one who hasn't said at this point, I think, is Portman.
This statement contains some interesting wording, quoting from Lamar Alexander. The question then is not whether the president did it, but whether the United States Senate or the American people should decide what to do about what he did.
About what he did?
Yeah, he goes into detail here. There is no need for more evidence to prove that the president asked Ukraine to investigate Joe Biden and his son Hunter. He said this on television October 3, 2019. If there's a baby splitting here, it is, hey, House managers, good job. It looks to you're right on the merits. I just don't think it's a role for
I mean, that's Senator Alexander
the
saying.
face you're making
He
speaks.
definitely did it. And I don't want to hear any more about it. And we shouldn't do anything about it.
Yeah.
I don't want to hear any more. I don't want to hear the evidence that further proves this case, because I believe he's guilty of what he has been charged with in the House.
But let the voters decide without the information from the witness with the direct
Right, because he's convinced, but he doesn't want the American people to hear the witness that can prove it, because they should make the decision without having the benefit of the information that would prove it.
And if he were sitting here, he'd probably say, well, they're going to get the information because the book's coming out in 3 weeks.
But
Right?
There's another point, though. The mere fact that Lamar Alexander believes the case has been proved and he doesn't need any more doesn't mean there aren't other senators who could use some more information.
Yeah.
Allow me to just read a little bit more from Lamar Alexander, because his colleagues are reading this tonight. There is no need for more evidence to conclude that the president withheld United States aid, at least in part to pressure Ukraine to investigate the Bidens. The House managers have proved this with what they call a mountain of overwhelming evidence. There is no need to consider further the frivolous second article of impeachment that would remove the president for asserting his constitutional prerogative to protect confidential conversations with his close advisors. It was inappropriate for the president to ask a foreign leader to investigate his political opponent and to withhold United States aid to encourage that investigation. When elected officials inappropriately interfered with such investigation, it undermines the principle of equal justice under the law. But the Constitution doesn't give the Senate the power to remove the president from office and ban him from this year's ballot simply for actions that are inappropriate.
Hey there, I'm Chris Hayes from MSNBC. Thanks for watching MSNBC on YouTube. If you want to keep up to date with the videos we're putting out, you can click subscribe just below me, or click over on this list to see lots of other great videos.